Okay, so today we're going to talk about more forms, but specifically removal forms and forms to apply for asylum. And I set these aside because they're pretty different in a couple of ways. They ask deeper questions, wider questions, and they just look different. And it can be easy to miss certain questions or misunderstand them. So I wanted to take some time today to talk about them individually. We'll go over each of them and what they are used for and who is going to adjudicate them, and also go specifically through each form so that you know what it looks like, what the questions are, and you can ask any questions you might have about any of those that you may not understand or may be a little bit new to you. So to get started, maybe, there we go. So these are mostly defensive forms. And what that means is usually they're going to be used in the setting of immigration court. Whereas most of the forms we were talking about in the first training were going to USCIS to be decided by a USCIS officer, probably just in their own office. They may have an interview in some cases, but mostly that's just form based. Those forms and the evidence packet go together. They're reviewed by a USCIS specialist. Maybe there's an interview, and then they make a decision in their offices. The difference is the forms we're going to talk about today mostly are reviewed in court. They're submitted to the immigration judge, and then there's going to be a big hearing where everything on that form is fair game, which means that the judge and the opposing attorney can ask about everything on the form and make sure there are no errors or inconsistencies. So while all of the forms are really important, these are the ones where somebody could really be grilled on the stand about anything that doesn't match up or that doesn't seem right. So it really is very important to get these forms right and review them again and again with the client, even, and make sure that they are being accurate, honest, and consistent about what they're saying. Because I have been in court with some immigration judges and some ICE attorneys who are very astute, and they can see an inconsistency a mile away, and they'll talk about it in open court. So these forms really are important, which is why I want to take extra time to go over them. The first form we're going to talk about today is the I-589, which is an application for asylum or withholding of removal, including withholding of removal under the Convention Against Torture. So essentially, this is asking about people who are asking for asylum from persecution or torture in their home country. They have some general questions in the first few pages, this I-589 form, about the applicant and their family, employment, and address history. But the majority of the form is actually these narrative blocks that are empty that you use to answer in a paragraph form why somebody can't go back to their home country and why they qualify for asylum. The other really important thing about the I-589 form is there is a deadline. With a lot of our other forms, there's not necessarily a particular deadline. We want to get them done fast to help the client and help them get status as soon as they can. With the I-589, if you are applying for asylum, you have to submit your asylum application within 1 year of entering the United States, which is a really fast turnaround, especially since people can have a hard time finding a place to live once they move here. If they're fleeing violence, they probably didn't have a lot of time to plan. They get here, they're trying to find a place to live. Finding an attorney is not a very high priority on their list sometimes because they're just trying to find a way to support themselves and their children. So in a lot of cases, they may come to us at the last minute, and we have a 1 year deadline coming up really fast. So that's something to remember. We can submit an I-589 after the first year, but we have to have a really good argument and proof for why it wasn't submitted on time. And the other thing I want to point out about the I-589 is it actually can be an affirmative or a defensive form. I think the majority of our cases are people who are applying for asylum in immigration court. So it is going to be accepted and reviewed and adjudicated by the immigration judge. Now, we do have some clients who are not in immigration court proceedings. And so if they're not in proceedings, we take the same form, the I-589, and send it to USCIS. And it is first adjudicated by USCIS. So the asylum application can be either an affirmative, as in going to USCIS, or a defensive, going to the immigration court form. Either way, it's a different kind of form that asks very different kind of questions, and I want to go over it in detail. The other form we're going to look at is the EOIR 42A. EOIR is Executive Office for Immigration Review, which is the fancy title for the Department of Immigration Courts. So you know it's an immigration court form because it starts with EOIR, or we can abbreviate it to the E42A. Now, the 42A is an application for cancellation of removal for permanent residents. So this means somebody who has already become a permanent resident, perhaps by marriage or by a family member or some other way. And unfortunately, they've done something or been convicted of something that means that their permanent residency could be taken away from them. So they have to go to court and show why they should be allowed to keep their permanent residency and not be deported. Typically, what I see this with is drug offenses. So if you become a permanent resident, but then you're caught selling marijuana or something like that, that can place your status in jeopardy, and you have to go to court and apply for cancellation of removal and prove why you deserve to keep your status and not be deported. We'll go over this form, but it asks a lot of kind of wide questions, general questions about the applicant, family, address history, employment history, immigration history, criminal history, biographic. It's a pretty wide and breadth form. It asks about a lot of parts of the person's life. The EOIR 42B is an almost identical form, and it's also an application for cancellation of removal, but for non-permanent residents, which means people who don't have permanent resident status. Most of the time, that means people who don't have any status at all. So for example, somebody who came illegally without permission and then later maybe got stopped for a DUI or just got picked up by ICE for some reason and are now in immigration court. And what they're doing is asking the immigration judge to cancel their deportation and give them permanent residency status, even though they didn't have it before. If they can prove all the elements that we're going to go over, if they win the case and win their application for cancellation of removal, their removal is canceled and they're given permanent residency. So it can be a really amazing form of relief, but it's very hard to win. All of these forms of relief are pretty difficult to win. They have pretty high standards. And we're going to go over the elements here in a second. The 42B and the 42A forms are almost identical. There are some parts that are different because the requirements are slightly different based on whether you're a permanent resident or not. But you'll see that for the most part, the forms are essentially the same.
Elisa, I cannot hear you.
You can't hear me?
No, I can hear you now.
You cut out for just a minute there.
Oh, where do I need to start over?
You said I'm going to go over the elements, and then you launched into something else, and I didn't catch any of what came after that.
Thank you. Okay, I appreciate you letting me know. Yeah, so we're going to go over the elements of this here in just a moment, but essentially what I was saying is you can see the types of questions that are going to be asked on the 42A and 42B forms. You'll see that the forms are essentially identical. There are a few things that are different because the, maybe length of time or specific elements are a little different for permanent residents as opposed to non-permanent residents, but for the most part, the forms are going to be the same. So you can kind of look at them and see that most of the questions are going to be the same, and they look very much the same. So let's talk about some of these elements. to start out, I don't expect you all to know, the deep legal requirements of these forms of relief. That's the attorney's job. But I do want to share with you why the forms are asking what they're asking. It's because there are a lot of particular elements that have to be proven to win asylum or withholding of removal or cancellation of removal. And I just want to list them out for you so that you understand what those questions are asking and why they're there. So the basics of asylum, and asylum law is anything but basic. I could spend months teaching you about this, but here are the basic elements. The person has to be unable or unwilling to return to their home country and unable or unwilling to avail themselves or take advantage of the protections available in their home country, because they may not have any protections available or the government may be unwilling to protect them because of past persecution or a well-founded fear of future persecution. And that persecution has to be on account of one of 5 things: their race, their religion, their nationality, their political opinion, or their membership in a particular social group, which is, I won't even get into the law underlying that, but to give you some examples, membership in a particular social group would include things like members of the LGBT community or members of a particular ethnic tribe in Nigeria. That's what a particular social group would be. So these are the basics of asylum. You'll see that there are a lot of questions about these elements in the I589, and it's because you have to prove these things in order to be eligible for asylum. Cancellation of removal has very different elements. For a permanent resident, the person has to have been a permanent resident for at least 5 years. They have to have been continuously residing in the United States for at least 7 years after they've been lawfully admitted. Again, I'm not going to get into the law about what a lawful admission means, but after they've been lawfully admitted to the US, they have to have at least 7 years where they were continuously residing in the United States. And they cannot have been convicted of an aggravated felony, which is a group of crimes that are considered particularly bad. Now, for a non-permanent resident who's applying for a 42B application, the requirements are different. They have to have at least 10 years of continuous physical presence, which means for them, they cannot have left the country at any point during the 10 years. They have to have been continuously inside the US for 10 years. They have to have been a person of good moral character during that time. And they have to prove that removal or deportation would result in extremely unusual hardship to qualifying family members who are US citizens or permanent residents. So actually the elements are pretty different. The time requirements are different, and you have to prove hardship for non-permanent residents. Well, that's not a requirement of the other. In spite of that, the forms are mostly the same, but the underlying requirements are actually different. Are there any questions about this so far?
No questions.
Okay, so I'm going to switch over to the actual forms, and we're going to start with the I-589 and just go through it so that some of you may not have ever seen this before or have never actually filled it out, so I want to show it to you. You'll notice it is I-589, just like an I-485 or I-765. It does look like a USCIS form. So in a lot of ways, it looks similar to the other ones. Like I said, it can be used for USCIS or the immigration court, but you'll see that it asks for some different kinds of questions. So to start off here, this is easy to miss. You have to check this box at the top if you want to apply for withholding under the Convention Against Torture, which is an agreement that states that if somebody will more likely than not be tortured in their home country, the US cannot return them to that home country. Again, the attorney who gives you this assignment should tell you whether we're applying for CAT, Convention Against Torture, or not. If we are, we have to check this little box up here, and it's easy to miss, but remember that this is right here at the very top. The beginning of the form is really pretty simple. Basic information, A number, social security number, name, other names used, your address in the US and phone number, mailing address if it's different, gender, marital status, date of birth, place of birth, nationality, and nationality at birth, almost always the same, but not always. And then 16 and 17 are pretty important because your asylum claim can be based on your race or ethnic or tribal group, or it can be based on your religion. Even if the particular claim is not based on either of those things, we need to list it there. It could be important. So be sure to ask people what their race is, if they're part of an ethnic group or a tribal group. So that could include an indigenous tribe for people in Central or South America. For people in Africa, many of them do have a tribal group, such as the Fulani tribal group in Nigeria. So be sure to ask about that. If somebody is a part of a specific ethnicity or tribe or indigenous group. And then religion also, I mean, that's pretty straightforward. People know if they have a religion or not, but go ahead and ask. I think some people feel uncomfortable asking that question and they don't really ask. You need to ask these questions, even if they feel like you're crossing a boundary, questions you wouldn't normally ask people, because asylum law is really based on these very, very personal characteristics. And it's very important to get it right and to list it all out on the form. Question 18 here has 3 different options. You should be able to figure this out by the consultation notes or by talking to the client. If they're applying with USCIS, they may have never been in immigration court proceedings. That may be true. Or they may not now be in immigration proceedings, but have been in the past. You'll need to look at those consultation notes and ask the clients. If we're submitting it to the court, that means that they are now in immigration court proceedings. Question 19 asks about travel to the United States. So for some people, they've traveled multiple times before and have even come legally. For some people, this is their first time and they came without permission or inspection. A big difference here, something to watch for, is question A and C ask different things. It's easy to get these dates mixed up. I've seen it done. A is, when did you last leave your country? C is asking for each entry into the US beginning with your most recent. So this date here would be, when did you last enter the United States? Sometimes these will be the same date. If somebody is from Mexico, they're just leaving Mexico to cross into the US, right? So the date that they leave Mexico and the date that they walk into the US is going to be the same typically. It will probably not be the same for people from other countries, Guatemala, Honduras, Venezuela. It takes time, obviously, to travel. So make sure that you get these dates correct. This is when they left their country, and it could be years or months ago. This is when they entered the US. And this is really important because that 1-year deadline that I told you about is based on that date that they entered the US. So we want to get that date right and make sure that USCIS or the court know that we're applying within that 1 year that they entered the US. Make sure to get the date right. So only people who entered lawfully will have this I-94 number. So they may or may not have it if you're applying for asylum. And here you enter all your entries, all of the person's entries into the US. So it may just be the one that they came through Brownsville last month, no status, no status. Or maybe they're Venezuelan and they've been here a couple of times before. So, you know, they came in 2016 and they came through Houston and they were on a B2 visitor visa. And then they came again in 2018 and this time was through Dallas, etc. And then, but this one at the top is the last entry and the date from which that 1-year deadline will be running. These questions are pretty straightforward. Just if they have a passport or travel document, you input the information here. 23 through 25 ask about languages. What is their native language? Are they fluent in English and any other languages they might also speak fluently? Most of my clients have Spanish, not fluent in English, and don't have other languages. But my African clients, maybe their native language is English and they're fluent, but they also speak several tribal languages as well. So just be sure to ask the client about all their languages. Moving on to the next page, we start asking about the immediate family members of the asylum applicant. So obviously, if somebody isn't married, you just click I'm not married and move on. If they are married, you have to fill out all of this. A lot of it is just general identity information, A number, passport number, date of birth, social security, full name, other names used, date you got married to them, place you got married, their place of birth and nationality, their race, ethnic or tribal group, also important to note, whether the person is in the US or not. If they're in the US, you have to complete these blocks down here. You don't if they're not. So when did they come to the US? How did they come? What's their current status? How long are they authorized to be here? Are they also in immigration court proceedings? They may or may not be if they came separately. Were they ever previously in the US? And then if they're in the US, are we including them? We can include derivatives in an asylum application to include a person's spouse and minor children. So if the spouse is here and doesn't have status or doesn't have permanent status, we typically are going to include them here. You'll need to pay attention to the consultation notes and perhaps ask the attorney to clarify if you're unsure, but we can include a spouse, even if the spouse is not the one subject to persecution or torture in the home country, they can be included as a derivative with the main applicant. And then we move down here to children. So this works similarly, essentially the same questions. If you don't have any children, obviously, mark that and move on. If you do, mark here and put the total number of children. I will say that this part of the form is poorly designed because when you get down here, this whole page here is all continuing children, a list of children, okay? So, and it all runs together. I mean, I guess there's a sort of darker line right here, and we go from question 21 to question 1, and then again down here from question 21 to question 1. It all runs together, but there are 3 different children that you can talk about on this one page. I don't know why they didn't design it better, but just so you know, be really careful because it goes just from like the end of the information about one child to the next child without a lot of warning. So just pay attention to that. So most of these questions are the same as above. And similarly, you can include minor children, children under 21 in the application. Look at the consultation notes, ask the attorney if you need to. But a lot of the time, if they have children without permanent status, they're going to include them in the application. Sometimes we'll also be doing a separate application for the included spouse or the included children. They may have a claim of their own. And they may even have a better claim than this person. So when people have kind of individual claims for persecution, we typically do separate applications for each of them, but also include each of them in case one person is a little luckier than the other and is able to prove their case better than the other person. Unfortunately, while parents can include children under 21, children cannot include parents in their application. which is kind of crazy, but that's how it works. So that's also why we will often do a separate application for the child as well, so that they have 2 bites at the apple, 2 opportunities to get asylum on their own and through their parent. So on these main pages here, you can list up to 4 children. There's 1 here, 2, 3, and then 4. There's a place at the end that I'll show you where you can, there's an extra page if you have additional children, more than 4, that you can list out. And of course, you can always do an addendum. And with these, you often do have to do some kind of addendum or additional pages to get all of the information into this form. This page is about the applicant's background. Question 1, you need to read very carefully. List your last address where you lived before coming to the US. And then if this is not the country where you fear persecution, also list the last address in the country where you fear persecution. So what that means is, again, for somebody from Mexico, it's probably just going to be their last address in Mexico. For somebody from, let's say, Colombia or Venezuela, they may have left their country and lived in another country for some period of time, may even just a couple of months before deciding to move on to the US. So their last address where they lived may be in Mexico. Maybe they lived in Mexico for a while. So you would need to put in their Mexican address, which is the last place they actually lived, and their last address in Venezuela or Colombia, the last place or their home country where they fear persecution. You may see this more with African clients, actually. I think a lot of even my South American clients don't tend to spend a lot of time in Central America or Mexico on the way up. I will see it more with maybe, it could be a Cuban client or an African client where they just escaped their country where they were in danger, and then they find another place where they live for a little bit, but it's still not safe, and so they decide to come on to the US. You need to put the last address in both of those countries under question number 1. Let me know if that doesn't make sense. Question 2 is pretty straightforward. This is just your residences during the past 5 years in any country. So where you're living now in the US, if you lived anywhere else in the US before where you're living now, if you lived in Mexico or any other third country on your journey, you would put that address. And then of course, all the way back for 5 years, which should include the addresses in your home country. So just go back a full 5 years. Again, there aren't that many lines here. I mean, there's 5 lines. Some people have moved around a lot, especially if they were really in danger in their home country and had to flee to different parts. So you may need an addendum to list out. And let me say this. What I see a lot in question 2 is people saying, well, you know, I went and lived with my sister-in-law for just a couple of weeks because I was in danger. And then I went back to my home. And then I went for a month to the country with my uncle because I was in danger. And to us, that may seem like, you know, you don't consider yourself living there maybe because it was just an extended trip. I think it's better to go ahead and list those out, particularly if it was in the person's country where they were persecuted or they feared persecution, because it helps demonstrate that they were so afraid and they were so in danger that they literally had to move. So if they had to move out of their home and live with someone else, even if it was sort of temporary, go ahead and list that there so that we sort of have it listed out. We have that proof, even at a glance, that they were being chased around in their home country, if that makes sense. Question 3 is also pretty straightforward about education, beginning with the most recent school. So if they attended high school, put that information, and then go backwards through all of their schools. Some people will only have gone to elementary school for a few years. Some people may have a college education. List it all out there. Again, as before, so notice here, with all of these, it's just asking for month, year. You don't need a specific date. It's enough to say 12/2019. That's what it's asking for. As we discussed before, if people really can't remember what month that they moved, or they were employed somewhere, or they were, especially back, like, when did you start grade school? I don't know when I started grade school. Like, what month was that? I don't, they may not remember. That's okay. It's okay to just put the year if you need to, if it's far enough back. Question 4, pretty straightforward. Information about your employment during the last 5 years. This one is really short. There are only 3 places, so you may need another page here. So again, this is any employment for the last 5 years. Being employed here in the US, even if they don't have employment authorization. If they worked in a third country while they were moving toward the US, while they were fleeing, if they stopped for some time and worked, include that there. And then any employment they had in their home country, of course, going back for the past 5 years.
Elisa, I have a question. For example, if they work from 2015 to 2020, but at this year they are unemployed.
Yes.
So oh, sorry, we have to place. Oh yeah.
So this is what I would do. Employed, Tulsa, Oklahoma, your occupation, unemployed, and then put the dates. That's what I would do to make it clear that you didn't forget something, that they actually are just not working.
Okay, perfect. Thank you.
Good question. Yeah, good question. And so that brings up a good point. You don't have to, if there's some question and it's not like super clear, there's a couple months gap, you can always just put unemployed in between the employment to make it clear that you didn't forget anything, you're not leaving anything out, they simply weren't working during that time.
Okay, makes sense. Thank you.
Okay, good. Yeah, no problem. Question 5, provide this information about parents and siblings, brothers and sisters. Okay, so again, there are only 4 siblings here. You may need another sheet. Put their full name, city, and country of birth, and current location, or if they have already died. This doesn't ask for too much information. It's pretty straightforward. But make sure you get all of this, because some people, I sit down with them and they think, when we're going through this, that they only have room for 4 siblings, and then they don't tell me about their other sisters and brothers. And I have to ask them, and they're like, oh yes, I also have 4 other brothers. Make sure to get all of them, and you can put them on a later sheet. Okay, now these are the questions that realistically you guys are probably not going to be filling out, because they are very legal in nature, and this is the basis of someone's legal asylum claim, which is very complex. I just want to go over it so that you know what it looks like and what it's asking, but you're probably not going to be the ones doing this. If you are, there will be a more intense training about asylum law if you become somebody who's doing asylum applications, okay? So here's where you mark these grounds, what is called protected grounds, the reason you fear persecution or torture: race, religion, nationality, political opinion, membership in a particular social group. And that torture convention that I mentioned at the top, it actually has 2 boxes, that one at the very top that's easy to overlook, and this one here. You've got to mark both of them if you are claiming protection under CAT. So here's that question: have you, your family, or close friends or colleagues ever experienced harm or mistreatment or threats in the past by anyone? And what I want to point out here, this is a really broad question. Read the questions really carefully. If anybody you're even remotely close to, even if you are not related to them in any way, has experienced even just threats, you can put that here. It's a really broad question that allows you to put kind of any harm, threats happening to you, your family, your friends, people you work with. And then you have to explain what happened. Question B, do you fear harm or mistreatment? This is always going to be yes. If the person does not fear harm or mistreatment, why are they applying for asylum? They're not going to win. So that's always going to be a yes. So this asks the person or their family members have ever been accused, charged, arrested, detained, convicted, imprisoned for in any country other than the United States. So this is not US, but it can be for an immigration law violation. So if they were detained in Mexico for crossing the border illegally by Mexican police, that would be a yes. This asks if the person or their family ever belonged to any kind of organization or group, and it lists out possible options. And if anyone continues to participate in the organization or group. Are you afraid of being subjected to torture in your home country or any other country to which you may be returned? And then you have to explain it. This asks if anyone has ever applied to the government for asylum status or refugee status before. Obviously, they're applying now. This asks if they ever traveled through another country to reach the US. And if they did, you have to give that information and whether they applied for any status. For example, coming through Guatemala, they probably traveled through Mexico. Did they apply for any status? How long were they there? Did they have any kind of permission to be there? This asks a bar question, what we call a bar question, because if you have inflicted persecution on other people for a protected ground, then you can't seek asylum. You can't treat other people the same way and then come and ask for asylum. This is an interesting question. After you left the country where you were harmed or you fear harm, did you return? Some people will say yes. They may have tried to leave before and they had to go back for some reason, and this time they've escaped for good. And if that's the case, then you write it out. Or things changed. Maybe they left before and they came back, and then things changed and got really dangerous, and now they have to get out because they cannot live there. Here's that question. Are you filing the application more than 1 year after your last arrival? If the answer is yes, you have to really explain why, because you have that 1 year deadline that's been violated. Again, this is very legal in nature. The attorneys are really going to be the ones working on it, but just so you know what these questions are. And then this asks if the person or their family has ever committed any crime, been arrested or charged in the United States. So it's different than that other question, which was about any place outside of the United States. Okay, here's this last signature page. You put the person's name, answer these little questions, have them sign, and then this is the information, usually of Lorena, the preparer. We'll include a G28 if we're sending this to USCIS. If we're not, there's no G28 because we're in immigration court. Don't touch this page. This will be filled out at an asylum interview with USCIS or the hearing before the immigration judge. Don't do anything on this page. Here are those final pages I was talking about. If you have additional children, you can list up to 2 more on this page right here. And then this page is just a general catch-all. If you need more space to list out answers to any of the questions, you can use this form here and mention which part or question. I have used this. If I just have a few questions that I needed extra space on, I might say part 2, question 3, answer. Part 3, question 5, answer. And I may do that on this page. Or you can do an addendum if you have a lot to say that's not fitting on here. You can just do a separate page and type it all out in a clear, organized way. And that's the end of the I-589. Before we move on, are there any questions about this one?
Not really, no questions. Since I haven't done one, I still don't have questions for this, but for sure I'm gonna have it in the future. Thank you.
Yeah, awesome. Yeah, always feel free to reach out with questions. This is just meant to be a general overview and answer common questions, but if you run into anything specific, reach out to an attorney or another assistant. Let's switch over to the cancellation of removal forms. So we have, this is the EOIR 42A, which is the one for permanent residents. This is the EOIR 42B, which is for non-permanent residents. You can see right away, they look pretty much the same. There are a few differences, but they are going to be mostly the same. We'll start with this one for permanent residents. The top of this is basic information about the applicant, all very straightforward biographic information. Okay, here we list out their address history. For a permanent resident, you have to go back for at least 7 years. But if we're doing a 42B for a non-permanent resident, you have to go back for at least 10 years. Because remember, you have to prove their continuous presence in the US for at least 10 years, but you only have to prove residence for 7 years for the other. So just be sure to read carefully. It tells you the instructions right here. This is a statement saying that the person wants their removal to be canceled and they believe they're eligible. Here are the elements. I've been a lawful permanent resident for 5 or more years. I have 7 years of continuous residence, and I have not been convicted of an aggravated felony. And then you put the information about where the person was admitted for permanent residence. Consult the consultation notes for this information. This is pretty straightforward. The person's first arrival to the US was under what name? When was it? Where was it? What happened? Were they inspected and admitted, or did they come unlawfully without permission or inspection? Mark the appropriate box and fill out the information. If they entered using a visa, you'll put the type right there and when it was valid until. Sometimes people can't remember this information, so remember to be honest. Try to help them find the information, work with the evidence specialist to look up the information. But if they really cannot get the information, then we got to be honest about that and say something like approximately 2005, but not sure. It's much better to be honest, because if you just say, May of 2005, the immigration judge is going to say May of 2005 it is, and look it up. And if it's wrong, or if the person says something different in the future, the judge is going to be like, why? Were you lying? What happened? It's not worth it. Just be honest if you don't know, or if the person really cannot figure it out. If the person came here perhaps on a visa and they applied for additional time to stay, you would put that information here. I don't see that very often. And remember, this stuff was about the first entry. So since that first entry, if the person left the US and came back, you list out those visits down here. And again, you may need an addendum, as another sheet to explain all of this. They may have come once and never left. And if that's the case, you just mark this box here and then move on. All right, and the thing I want to mention about these forms is they're also poorly designed, because it's easy to skip over questions or to think that questions are associated with a different question when they're actually a whole individual question. So like question 24 here can be easy to overlook. It can be easy to, it kind of looks like it's part of this, right? But it's actually a separate question. So you've got to like read very carefully every single line and make sure you're answering every question. I have seen seasoned practitioners get to court and the judge say, you didn't answer question 24 or whatever, because it's so easy to miss. So you just want to take your time with these because they're badly designed. Make sure you answer every question that is applicable. So this is, have you ever departed the US under, and this is the words that we talked about that have specific meaning last time, an order of deportation, exclusion, or removal. A voluntary departure is separate. It's asked in this separate line here. This does not include voluntary departure. And a voluntary return is not included under either of these questions because that's a completely separate thing. All right, part 4, information about marital status and spouse. A lot of this is straightforward. Are they married or not? If so, information about the spouse, when and where they were married, where the spouse is a citizen, If they're not a US citizen, they have to include this information, and then whether or not the spouse is currently employed. This is pretty straightforward. I don't think I need to go over it. This asks about any previous marriages. So mark whether they have or have not been married and list out the information. Question 36 is really easy to miss. I have missed it before. It just disappears in between like these bigger boxes. But so don't forget question 36. Have you been ordered by any court, or are you under any legal obligation to provide child support or spousal maintenance as a result of separation or divorce? May or may not be yes. It probably will not change anything unless the person has been refusing to pay child support, and then we have a good moral character issue. But just don't forget this question. It's easy. I have forgotten it. Other attorneys have forgotten it. It just disappears. So pay attention to that one. Learn from my mistakes. Part 5, information about employment and financial status. So again, read these carefully. Since my arrival to the United States, I've been employed by the following named persons or firms. So while it was only asking for your addresses for the last 7 years, you need to provide employment since the person arrived in the United States. So you'll put the name and address, earnings, type of work, and date. If the person is self-employed, you have to describe it more fully here. And all of the requirements, what you need to describe is listed right here on top. On 39, we list assets, both that are owned exclusively by the applicant and ones that they own with their spouse. So cash, stocks, and bonds, I don't see that very much. People, in my experience, don't have a lot of that. Real estate, any houses or property they own, any vehicles they own, anything else they might own that might be an asset, and then total those up. Question 40, read carefully. This is the key word here. I have or have not received public or private relief or assistance, which means if my child has, that doesn't matter for this question. This question is only about I. Have I ever received welfare benefits, unemployment, Medicaid, food stamps? If I have, then I have to list out what I received and mark I have. But if anyone else in my family has, but it wasn't me, the answer is no, I have not. Okay. 41 is list each of the years in which you filed an income tax return with the IRS. Hopefully this is every year for the duration of the period we have to prove, or for a permanent resident, hopefully it's every year, at least since they became a permanent resident, hopefully every year since they came to the US. Hopefully the attorney will have looked into this. If somebody really hasn't paid any taxes, probably talk to the attorney, because we need them to get on paying those taxes before we get to trial, because it's going to look bad. But ask them, and again, you may get some of this information from the evidence specialist, because we'll want copies of all the taxes. So you may just wait until the evidence specialist gets those in so you know which years were paid. Part 6. Again, I have X number of children, and there's only 3 spots here, so you may need another page. Just put the information about the child. If they're over 16 and they have a separate income or assets, you would list that here. That's not usually applicable. And the immigration status of the child in these boxes. 43, if your application is denied, would your spouse and all of your children accompany you to your country of birth, country of nationality, country of last residence? In a lot of cases, this is all the same country. It may not be, but in my experience, the country of birth, the country of nationality, and the country where they last lived are the same. Typically, we're going to mark no and explain, my children are US citizens. They need to stay here for medical treatment or education, or maybe the person shares custody of US citizen children and they can't take them with them to Mexico or wherever. We explain briefly why their family can't go with them, because the point of this is to show if somebody could easily move back to their home country and take their family and everything be great, they're not going to be able to show the extreme hardship that's required to prove cancellation of removal cases. So we're typically marking no and explaining why those people cannot go with the applicant, why it would be such a hardship, whether it's medical, educational, legal issues, whatever it is, we kind of summarize it here. And it can be pretty generic. We're going to prove a whole case and send a lot of evidence and get psychological evaluations. This isn't proving the whole case. We're just summarizing what the basis of our case is, if that makes sense. Now, this is that similar question to the one above where we asked if I had ever received any assistance, but this question is whether members of my family, including my spouse or children, have or have not received public or private assistance. So if somebody is getting food stamps and yeah, it comes to them, but it's in their child's name, you do not mark question 40 or 41 above, you mark this question, question 44, because really those food stamps are in the name of the child. So if the kids are getting food stamps and Sooner Care, for example, you will write that out. My child, Benny, has received food stamps since August of 2018. He has had Sooner Care since he was born in 2017. Just to explain it all out there. Question 45 is always going to need an addendum. There are only 2 spots here for 2 family members. But if you read this here, it says, please give the requested information about your parents, brothers, sisters, aunts, uncles, and grandparents, whether they are living or dead. That's a lot of people. Even for somebody from a small family, they're at least going to have 2 parents, 4 grandparents, at least. And there are only 2 spots right here. So you are always going to need a separate piece of paper, an addendum, to list out the person's family members. And remember, some people just don't bring up somebody who has died, but we have to include them, even if they have died. It says living or deceased. So even if all of their grandparents have already passed away, we have to include the information about those grandparents. So this can be as short as just parents and grandparents, and there are no aunts, uncles, brothers, or sisters. Usually it's going to be much longer than that. They're going to be far more family members, and you're going to need to put all of this information for each family member on an addendum. And I get this question a lot with folks. They're worried, right, about putting their undocumented family members' information on this form. I have never seen or heard of an undocumented family member getting hunted down because they were listed on an application for cancellation of removal. I understand why people are worried about that. I've never seen it happen. If somebody is really, really concerned about putting the address, sometimes we can just put maybe like San Francisco, California, and not put the address line, but it's not going to harm them to put the address for an undocumented family member. I've never seen it happen, that anything negative happened because of that. Okay, on this page, we're just reading carefully. Entering the United States as a crewman, that's a very specific legal thing. I've never seen it happen with any of my clients. Whether you've been admitted or acquired the status of an exchange alien, so that's pretty specific. I don't usually see that. Whether the person has submitted address reports. So this is for permanent residents. So hopefully they have been submitting address reports, which means they have to keep their address updated with USCIS until they become a citizen, or, you know, if they actually, even if they leave the US, they might have to as well. So if they're not yet a citizen, they're supposed to be reporting their address whenever they move. This is a broad question about criminal history. Whether the person has or has never in any country, the United States or any foreign country, been arrested, summoned into court, convicted, fined, imprisoned, placed on probation. So this is a really broad question. So, and it says including, but not limited to, traffic violations or driving incidences involving alcohol. So I know sometimes there's a question about whether to include traffic tickets. This is really clear. You include traffic tickets, you include DUIs, you include things that happened in other countries, you include just being arrested for something, even if you weren't convicted or charged. This is a broad question. So if the answer is yes, which for most people, they have at least gotten a traffic ticket, you have to explain it here. 2005 speeding ticket in Laredo, Texas, paid fines. And that's usually sufficient for something like that. If it's a bigger deal, which usually if they're a permanent resident doing cancellation of removal, there is a bigger criminal problem, such as, oh yes, I was convicted of possession with intent of marijuana, then we're going to have to explain that out here. Question 50 is if you've ever served in the armed forces. Usually people have not. They usually, even if they try, get turned away because of their legal status. These are those similar questions to the I-485 about whether, whether you avoided getting into the military for some reason or deserted the military. It's usually not the case. 53 is important. For males who were here between the ages of 18 and 26, they were supposed to register for the Selective Service or the draft. Most people did not know that. For people who are already in their 30s or 40s, they're already beyond that age. They may not have done it. That's okay. Just mark no and explain that they did not know it was a requirement. I didn't know it was a requirement until I started doing this. There's no reason most people would know that, especially if they have no status. Some people may have registered. If so, you can look it up online. If they have any of with their information, you can look up their draft number. Now, for men between the ages of 18 and 26 now, if they have not registered, we can help them get registered so that they can mark yes and show kind of better character. So if you notice that your applicant is between 18 and 26 and they're saying they never registered, let an attorney know and we can help them go ahead and get registered for the draft so that we can mark yes on that. Okay, question 55. Again, this question about whether the person has ever been a member of any kind of group or association or organization or foundation. Most people haven't, but go ahead and ask. And then these are questions. These are questions about immigration history. Has the person been ordered, deported, excluded, or removed? Again, those are specific words. That doesn't include voluntary departure. Have they overstayed a grant of voluntary departure? So if they were given voluntary departure and they left in the right time, this is no, they didn't overstay it. Did they ever fail to appear for deportation or removal? So if they were ordered removed and they showed up to be deported when they said they were supposed to, the answer is no. It is only yes if they actually failed to show up when they were supposed to be deported. And then these are kind of some weird questions. Is the person a habitual drunkard? Hopefully not. Hopefully nobody would ever admit to that, and we don't want to admit to that. So typically no. One whose income is derived principally from illegal gambling. Again, even if it were the case, which I haven't seen, hopefully somebody, I would be shocked if somebody admitted to that, but one who's given false testimony for the purpose of obtaining immigration benefits. We have gone over some of these questions in the I-485. This is if they have stated something false to get a visa or applied, maybe they were fraudulent and they applied for their permanent residency. The prostitution question, the polygamy question, immunity from prosecution, I've never seen that. This is the smuggling question. Did you ever bring in another person to the United States illegally? We've gone over that. A trafficker of a controlled substance. This can get a little funky with people who have been convicted of drug crimes. If you're not sure how to answer this, ask an attorney. Typically, we're not going to admit to being a trafficker because because that would be a big deal. But so typically the answer is going to be no. If you're just not sure about how we answer this, ask an attorney. Are they inadmissible or deportable on security related grounds? Typically no. This is that question we saw in the I589, one who has actually persecuted somebody else because of their race, religion, nationality, political opinion, particular social group. Hopefully the answer is no. I've never seen it be yes. These are specific legal sections. Usually these do not apply. The attorney would be the one responsible for making sure that this is the correct answer, because you have to read and interpret the statute to find out whether this applies. Usually it doesn't. This is really up to the attorney. And if you answer any yes questions up here, you have to explain it. And this is, again, a summary. We're going to go in depth with the evidence and the hearing. This is simply a summary of the response. Here, essentially, this is what we're always going to put. Okay. To be submitted according to the immigration judge's instructions. We're going to submit a bunch of evidence, but typically we more or less wait for the judge to say, this is the call-up date, this is when we need all of your evidence, submit it then. So just as a general rule, we, instead of listing it all out here, because also we're going to submit way more evidence than we can list here, we just say, this will be submitted according to the immigration judge's instructions, and we leave it at that. This is the signature page for the preparer. Now, okay, so you will prepare this for Lorena or whoever the preparer is. Don't touch this. This says application not to be signed until the applicant appears before an immigration judge. They do not sign this until they get in front of the immigration judge in court. So leave this alone, don't fill it out. This is a proof of service, which you've probably never seen before. Everything we submit to the immigration court, we also have to submit to ICE. It's just the principle of fairness in American courts, that whatever is given to the court has to be given to the other side. Typically, it will have been mailed, and you can leave the date empty for whoever is going to mail it out. And if you're not sure who ICE is or where it goes, typically it's going to be ICE in Dallas. You can look it up. Don't worry too much about this. Most of you are not going to be doing removal forms very often. It's okay if you leave this blank and you don't know what it is. I'm not too worried about that. It's outside of your regular duties. So that's the 42A. The 42B, we're going to speed through. It's almost exactly the same. This is the same. You just have to go back for 10 years. Here you have to mark who is going to suffer that extreme hardship like we talked about. So that's going to be, oh, and let me make this, since we talked about hardship on the 42A, we can still show hardship, even though it's not a requirement for a permanent resident to show that extreme hardship. Here, we typically are still showing hardship as to why their family can't leave, because that's an additional discretionary reason as to why they really deserve to have their status here in the US and they don't deserve to be deported. Even though it's not an element, we still try to show it wherever we can. With the 42B, for an application for somebody who's not a permanent resident, we have to show that extremely unusual hardship. And we have to mark out who it is, whether it's a spouse, a parent, or a child, and whether they're a citizen or a permanent resident. Okay. This is VAWA special rule cancellation. Most of our VAWA cases are affirmative. We're sending them to USCIS. But we can also show that somebody, due to extreme cruelty, that's essentially a VAWA case, that they deserve cancellation of removal if they're already in removal proceedings. It's sort of this cancellation of removal specifically for VAWA applicants. So we don't have very many of these. Occasionally we do. You would mark this box if we do. You're not going to see it very often, maybe more in the future, but that's what this box is for. This, what's called special rule cancellation of removal. And it's for battered and abused immigrants who would otherwise qualify for VAWA. Okay, so this is similar questions about arrival in the United States, whether they were admitted or not, whether they have left the United States or not since that first time. And then we jump down to marital status and spouse. This is essentially all the same as the other one. Any previous marriages. This one actually asks if their present spouse has been previously married. So you would mark that and explain it if so. Same question here. Have you been ordered by any court to provide child support or spousal maintenance? Don't forget this one. It's easy to forget. Employment and financial status. This is essentially the same. And in the same way, it asks since the arrival into the United States, not just the 10 years, going all the way back to their arrival in the United States. If self-employed, describe it. We have the assets here. This same question, whether the actual applicant has received any kind of assistance. And the question about the family is on the next page. Any of the years they filed a tax return with the IRS. Any children, information about the children. This is where we really do put no and explain that extremely unusual hardship because it is actually a requirement. It's a discretionary factor for permanent residents. For this, for people who are not permanent residents, it's a requirement. We've got to explain why their family is going to suffer so much hardship if they are deported. Here's that question, whether members of the family have received any kind of assistance. And again, we're asking about their extended family here, and we're going to need an addendum because you have to go over parents, brothers, sisters, aunts, uncles, and grandparents, living or deceased. It's going to be more than 2 people. You've got to have another page. This is an additional section that's not in the other one. I don't actually have to use it very often. It's if the application is based on hardship to a parent. Usually that's not the case. It can be the case. So if they have a US citizen or permanent resident parent who is going to suffer extreme hardship, then you fill this out about the parents and their assets. I have not yet had a cancellation case where that was really the case. So you may or may not fill this out, but it's pretty straightforward. Okay, same questions here. This question about any kind of criminal history, we've already gone over that. Armed forces. Same thing with the Selective Service Act with the draft. Even if the person currently has no status, we can sign them up for the draft and then mark yes, and then they look better. Same thing with organizations, any kind of organizations they've been part of. And these are pretty much the same questions that we went over before. Again, if you answer yes, you have to explain it in summary. Are you the beneficiary of an approved visa petition? So usually for a cancellation of removal cases, the answer is going to be no. If somebody has applied for them, that would be one thing, but usually the answer is no. Same thing here, to be submitted according to the immigration judge's instructions. Instead of listing out all of the evidence, we're going to do that separately. We'll submit a table of contents. It'll be really nice and organized. We're not going to list it all out here. We just say to be submitted according to the immigration judge's instructions. Okay, this is that preparer information, typically Lorena. Don't touch this. And that's that proof of service, which again, if you don't know, don't worry about it. A paralegal or an attorney can take care of that. Okay, I kind of went through that one really fast, but it really is mostly the same. And the key to all of these is read the question really carefully. So let me stop sharing. That took a little longer than I anticipated. We're just over an hour here. So any questions? Anything I can clear up from there?
I don't have any question, Elisa.
Okay. Hopefully that made sense and it wasn't too confusing. I know those are very new forms and they're so poorly designed. Truly, they're like designed for you to miss things and make mistakes. But hopefully that helps to clear up any confusion or at least get you introduced to those forms if you ever have to do them.
Yes, of course. If I have to work on one on this, of course, it's going to be so much easier
Good.
start from your training.
Good.
And like I said, for sure, I'm gonna have questions, but it's gonna be easier with the information that you just gave us. Thank you.
Good. Yeah, you're welcome. Anyone else have any questions, concerns? All right. Well, thank you. Go ahead. No? Okay. Well, thank you all so much for being here. I know you're tired of my face. I've been doing a lot of trainings lately, but I appreciate you being on here.